Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, I'm Annie, and I'm joined here today by Martin Brazier, who's one of our senior data protection consultants here at URM. Welcome to another episode of Talk DP. So in this podcast today, we're going to be looking at the data protection considerations for artificial intelligence or AI systems. So Martin, first of all, what is AI? Big question.
Well, yeah, and there isn't really a good answer. There wasn't an agreed definition of artificial intelligence, not least because it covers a wide range of technology and has evolved slowly over time, of course, but it generally applies to those systems that learn from data sets rather than simply following a list of pre-programmed rules. In its recent AI Act, the European Union provided a definition of an AI system, but it ran to several pages, so it's not really a snappy definition we could use here. But most implementations of AI involve a two-stage process. The first stage is a training, development, or learning phase, whereby the system looks at a data set, usually a very large data set, to determine its characteristics. The second is a production or deployment stage, where the system is asked to produce outcomes from the learning it's made in the first stage. Both stages serve different purposes, both can process personal data, and both present slightly different data protection challenges. But as the reactions are learned and not programmed, how that system has reached a conclusion might not be entirely clear. It kind of operates in what's often called a black box. And this underlying sort of characteristic produces difficulties with achieving data protection compliance, which don't occur in traditional data processing. And this can include a vagueness about the source of the original learning data, bias introduced through reliance on the original data or through algorithms, and inadvertent use of personal data or intellectual property.
You mentioned the EU's AI Act there. How is the UK legislative framework evolving?
Well, I think slowly is the short answer, but of course the EU AI Act applies only in the EU, of course, and UK is no longer in the EU. So in the UK, the government published a white paper in March of 2023, which focused on adopting and adapting existing legislation and regulatory regimes instead of the European Union's more prescriptive and legislation-driven approach taken in the AI Act. Then in August of 2023, a House of Commons report suggested that the white paper's approach risked the government being left behind by that more prescriptive tactic being taken by the EU, and proposed an AI bill to be included in the King's Speech in November 2023, although that didn't actually happen. At that time, the government's intention seemed to be to provide oversight via the Information Commissioner's Office, the ICO, and other existing regulatory bodies, including Ofcom and the Financial Conduct Authority. The ICO issued guidance on how to use AI and personal data in late 2022, around the time that it collaborated with the Alan Turing Institute to issue a paper on explaining decisions made with AI. Updated ICO guidance on AI was issued in March 23. However, the King's Speech we've just had on the 17th of July touched on the new government's proposed approach to AI, and while no specific legislation was mentioned, it was stated that the government will seek to establish legislation to regulate the development of AI. This deviates from the approach proposed by the previous government, which took a sort of non-binding approach to regulating and developing the use of AI.
What are the key aspects of data protection that AI causes us to think about in a different way?
Well, some of the established AI services, such as the ChatGPT, Bing, and Lambda, use large language models to generate text in response to an input from a series of questions or instructions. The service then provides answers drawing on its learning from that large language model through a process of recognizing, predicting, and generating content. One of the initial risks is that personal data may be included in that large language model, which will find its way into the generated output. The mainstream AI services are infamously vague about the origins of their data sources, so the users of the output may never realize that their output contains or was generated from personal data or even information forming the intellectual property of others. But the principles of the UK General Data Protection Regulation, UK GDPR, include lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, and so on. So let's have a little look at some of those in a bit more detail. First, we can consider fairness and lawfulness. To process personal data, you must have an appropriate lawful basis under Article 6 of the UK GDPR. As the use of AI involves two processing stages, the training and the production stages, this means ensuring that there's a lawful basis for each type of processing, and the lawful basis could be different for each stage. If the proposal that you're considering involves processing special category data, which includes data about health, race, religious beliefs, politics, biometrics, sexual orientation, and so on, then there is a need to identify an additional legal basis under Article 9. One potential Article 9 basis is explicit consent, but this is often difficult to acquire in practice, particularly given the challenges of explaining how AI would process an individual's personal data. But this might be the only option, for example, if there's no substantial public interest, such as the prevention or detection of crime, for example. Furthermore, there's likely to be considerations of necessity and proportionality, and context, after all, is everything. As understanding AI is impenetrable to many, ensuring that processing is fair can be a challenge, not least because fairness centres around processing data in a manner which individuals would reasonably expect. It remains an issue that AI systems can reflect bias in learning data sets or create bias where none previously existed. So it's important to ensure that the system is sufficiently accurate and thoroughly tested for bias before implementation. There's also need for transparency, and the UK GDPR requires a controller to inform data subjects what information they hold about them and how they're using it. The complexity of understanding how AI systems work and how they might process personal data translates into a sort of perceived lack of transparency, which can make it difficult for controllers to explain those decisions to data subjects if the algorithm and the data sources are opaque. The ICO has recognised the difficulty of this explainability and has produced guidance in collaboration with the Alan Turing Institute, which is definitely worth a read. The EU's Article 29 Working Party also produced guidelines which are worth checking out. In certain circumstances, the right to be informed can be waived if the data was not collected from the data subject, for example. If it can be demonstrated that informing data subjects is impossible or requires disproportionate effort, that's in UK GDPR Article 14. However, for the exercise of rights, such as the Article 22 right relating to automated decision making, it's essential to provide detailed explanations to the data subject. Even if regulators recognise the difficulty in explaining AI processing, there is nonetheless an obligation for controllers to provide as full a description as possible about the source of the information and how any outcomes have been derived, and do so in the plainest possible language. And there's really no easy answer on how you do that. The purpose limitation principle I mentioned requires that personal data must only be collected for specified, explicit and legitimate purposes and not processed further. Learning data for AI can be collected through a process called data scraping or web scraping, where data from various sources is compiled on a huge scale and may include sources from social media and the internet in general. Due to the almost indiscriminate nature of this process and its sheer scale, personal data will be included without any record that it's been included, and it may also collect data which is untrue or inaccurate, or which forms the intellectual property of others. Consequently, this method is almost the exact opposite of that required to comply with the purpose limitation principle. There's also the matter of data minimization, and the UK GDPR requires the processing of personal data to be adequate, relevant, and limited to what is necessary. The nature of compiling huge data sets for learning models means that, again, this process is at the opposite end of the scale from only processing what is necessary and no more. This is particularly troublesome when the data set includes special category data. Under the accuracy principle, any personal data needs to be accurate and, where necessary, kept up to date. As data is collected in such large volumes for learning models, it's not always possible for it to be verified or checked in any way. Moreover, the data once in the model may be unrecognizable and difficult to correct. Inaccurate information, whether it's personal data or otherwise, and information which introduces or produces bias, is one of the main issues with commercial chatbot services. Under the stories limitation principle, personal data must be kept in a form which allows identification of data subjects for no longer than is necessary. Again, as with the accuracy principle, this is difficult to achieve with many AI models. Provided the controller can justify longer retention periods for data in the learning systems, which is proportionate to the purpose of the AI system, there's no reason why data couldn't be kept longer than would it be the case in a conventional scenario. And we shouldn't forget the accountability principle, which requires controllers to maintain good records from the beginning of the development, which will not only enable a controller to demonstrate GDPR compliance, but will help to explain the processing to data subjects and regulators. If an AI model is intended to make automated decisions about individuals, there's further challenges. As the law currently stands, data subjects have a right not to have decisions made about them purely by automated means, on the basis that important decisions, such as for a mortgage or a job application, should not be handled solely by an algorithm. The first hurdle is that you must tell data subjects about the automated decision making and how it works, which brings us back to the issues of transparency and explainability. One solution is human intervention, that's requiring a human to ratify the decision made by the model. But with the complexity of AI systems and their data sources, would it be possible for a human to make an informed and meaningful assessment about whether the model's decision was correct? An alternative solution is to undertake the automated decision making with the data subject's consent. But again, this involves explaining the decision making process clearly so that the consent is fully informed. AI services present problems with the practicalities of meeting data subjects' rights requests as well, such as the right of access, rectification, erasure, and so on, because personal data in AI models is often difficult to identify and extract. Also, the rights apply to both the personal data contained in the learning model and those contained in the output of production. To avoid arriving at a place where data subject rights can't be met, the principle of data protection by design and default should be adopted, with the exercise of rights built into the solution at the earliest stage.
It sounds to me like these are new problems which are going to need new solutions. So what should we consider to achieve data protection compliance in AI systems?
One of the most significant risks associated with AI is the speed of change. And data controllers, are in a rush now to deploy the benefits of AI. Many controllers are outsourcing the development of AI systems to specialist third-party developers, not always with properly developed detailed system specifications, which results in only the developers understanding how they really work. Contracts that ensure lasting ownership of specifications, intellectual property, patents, and so on could become critical as small software firms are required and absorbed into bigger firms as the industry progresses. One of the most important things is at the earliest stage to produce an explanation for how the system works. This needs to be written in the plainest possible language, including the source of the learning data, its accuracy or output, and the mitigations in place to avoid bias, error, and discrimination. Focus groups could be used to test out the explanation so that it can be used with confidence when presenting it to employees, data subjects, and the regulator. So we should consider implementing a continuous improvement approach. The AI systems generally learn continuously, where data used or produced in production is fed back into the learning model to improve learning and effectiveness. There are risks that some of the key characteristics will creep, introducing or worsening discriminatory bias and the deterioration of the accuracy of the output. This arises from the use of the same data for two purposes, that for which the system is intended to use in production and the intrinsic improvement of the learning model. This requires continuous monitoring, which can detect issues early and identify improvements. The assessment of AI systems is a key part of the EU's AI Act, by the way. It's necessary for validating the learning phase with the aim of objectively verifying that the learning platforms work in the way they were designed to work and are suitable for the deployment in the production phase. It also minimises the risk of scope creep over time, particularly if the profiles of the individuals whose personal data make up the learning data is different from those at which it's aimed in production. Next, we should try and avoid that discrimination and minimise the data that we're using. There is a need to determine the data necessary to train the system and not to rely on more is better approach. The quality of the learning data must be balanced against the purpose of the system in production and in line with the proportionality that's inherent in all data protection law. So a few things to think about when building a learning data set are deciding whether the personal data is necessary for the model, whether it can be anonymized or pseudonymized, or whether filtering or masking mechanisms can be used. Distinguishing between data for learning and the production phases. Documenting the process in line with the accountability principle, including sources, data compilation and verification of data integrity. Regularly assessing for privacy risks of data subjects in line with their rights, and finally being vigilant with information security. And I think you should also consider appropriate risk mitigations. And despite the new and unique data protection challenges posed by AI, it doesn't necessarily mean that deployment of compliant AI systems isn't possible, but it does mean that those new risks should be mitigated appropriately. And those mitigations might include thoroughly testing the system on a reliable data set with outcomes analysed to ensure that they are commensurate with the objectives of the system and the law. In the rush to completion, developers need to be certain that learning data sets have been established from lawfully obtained data processing. Mitigations might include sampling outputs from the system to be reviewed on an ongoing basis to confirm the quality of the outcomes, particularly where those outcomes are fed back into the learning data set. Adding confidence limits on outcomes with associated flags for any outcomes which exceed those predetermined limits. Providing quality responses in reaction to automated decisions which explain the process and why the decision has been made. So, for example, if a mortgage application is rejected using an AI system, the feedback could be that the application would have been accepted had the loan amount been lower by X pounds or the applicant's income had been higher by Y pounds. And lastly, learning from others. For example, there's some excellent controls required for algorithmic trading in the financial services industry, in the Markets and Financial Instruments Directive. And I think that as a final point, there are some established methods to assess and record your decisions. Data protection impact assessments, or DPIAs, are mandatory for high risk processing, and the process will be familiar to data protection officers. DPIAs provide an essential template to record the risks, mitigations, and the design thought process. If the lawful basis that's being used is legitimate interests, then a legitimate interest assessment is essential. It compromises a purpose test to identify the legitimate interest of the processing, a necessity test to consider if that processing is necessary, and a balancing test against the data subject's interests.
Thank you very, very much, Martin, for taking the time out to sit and chat with me today. For those of you that want to learn a little bit more about this subject, Martin's written a really great blog on the topic called Data Protection Considerations for AI, which is available at urmconsulting.com. And we haven't covered it in depth, but we've briefly touched on the EU AI Act here today. So if you want to find out a bit more about that AI Act, you can also go and look at another blog that Martin's written on our website. So thank you very much, Martin, and thank you for listening. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube, and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.